Hello, everyone. Sorry for being just a few minutes behind with our big launch of our live today. And for those of you who've watched the channel, this is an area that we have not focused on a lot, but there is a very, very good reason why we're doing it now, and that is humanitarian and compassionate applications. Ronalee, how are you doing? My special guest.
Hi, Mark.
So, how's things in Ottawa for you?
It's snowing. It didn't snow all
Really?
winter, and now it's snowing.
Oh man, it's been beautiful here. It was literally 19 degrees Celsius yesterday. It was so nice out. And I think tomorrow the snow's supposed to be coming our direction, but no, I'm sad that you've got snow there. That's too bad. All right. Okay. So those of you who are connecting in, we are absolutely going to be having a Q&A as a part of this. But what we want to focus on today is really to helping people understand what this humanitarian compassion application is all about. And for all intents and purposes, it is kind of when everything else fails, that's the focus. And I've invited my friend Ronalee Carey, who's a Canadian immigration lawyer based in Ottawa, to join me this evening. And we decided to do it at this time versus later for the simple reason, or I should say earlier in the day when we're both technically work hours. This is way into our family time, but we wanted to do this because we wanted to wait for everybody to get home so that they would have the ability to watch this. Now, as is always the case, there's many, many people that are tuning in. They watch this as recordings. So what Ronalee and I are going to talk about is how and why this might be a possibility if you fit within the narrow parameters of humanitarian and compassion applications. And so we've got a bunch of people that are connecting in. Don't hesitate to post questions, and then I will get to those. And if you have a good question when Ronalee's explaining something, I will also pull that in. But today is all about humanitarian and compassion applications. And so with that being said, Ronalee, why don't we just jump in and cover the first topic, which is, what is an H&C application?
So there's actually two types of H&C applications. So for people who are inside Canada, they can make an application for permanent residence based on humanitarian and compassionate factors. It's a standalone application. It's done through a portal. You upload supporting documents, and it's determined by an office here in Canada. But there's also the ability to have humanitarian and compassionate factors considered in applications that are made from outside of Canada. And it's also possible for humanitarian and compassionate applications to be considered in other types of applications. For example, a parent and grandparent sponsorship application for someone who was selected in the lottery, but the sponsor doesn't technically meet the minimum necessary income. I've successfully had humanitarian and compassionate considerations applied. So it's not an H&C application, but H&C factors were still considered.
Gotcha. And I think one of the things for those that are tuning in, what Ronalee basically is going to explain, and as we move forward, yes, it can be a standalone application, but within a lot of different applications, you can make what we call humanitarian and compassionate arguments. And so I'll give you an example. And as we get into more details, we'll be able to dive in a little bit deeper. But some of you may have applied through the TR to PR pathway program. And in some instances, with the crazy race to file, sometimes people maybe didn't realize that for whatever reason, they didn't meet the eligibility requirements. In the case of one of my clients, they had graduated from a post-grad work permit granting institution. So it was a DLI, but didn't grant postgrads. And she had secured an LMIA and was working for a company in Vancouver. But she got a procedural fairness letter back from IRCC that said, hey, you are ineligible for the TR to PR pathway. And of course, it's like 1 year after they filed, right? Because it took forever for these to be processed. And in her case, they came back and sent her a procedural fairness letter and said, we don't think you're eligible. So we'll give you an opportunity to explain to us, well, whatever, your rationale as to why maybe you think you are. So we immediately included humanitarian and compassionate submissions to explain a whole bunch of factors, which we will get into later in this video. And we were actually able to transition her TR to PR pathway to a humanitarian and compassionate application. And in the end, it was approved, whereas otherwise she would have been toast. So for those of you who are finding yourself in situations like that, there is possibilities, but the agency factors have to be in your favor. and we will get to those. Yes, Ronalee, I know you've got
And the
something
one thing,
insightful.
yeah, the one other thing I would add is that this is only applicable for applications for permanent residents. The section of the legislation does not apply to applications for temporary residents.
Yes. And while you're on that topic, then what would apply to a temporary resident application?
Well, in that case, this, in terms of humanitarian and compassionate
Well,
factors,
let's talk about, yeah, kind of like that. So, and I'll even answer my own question here. I don't mean to set you up. You know, a TRP, right, would be
yeah,
kind of
okay,
like
that's what I thought you were getting at.
yeah,
So a
yeah.
temporary resident permit is for people who are inadmissible to Canada or do not otherwise meet, requirements of the
Mm-hmm.
legislation. So that would be the kind of permit that you would apply for if you weren't qualifying for another kind of permit.
Right. And one example that we see a lot in the use of the temporary resident permit is when you guys forget to renew your work permit, or you're out of status longer than 90 days and you're basically hooped. And so the only option you have to try to save yourself, unless you're prepared to leave Canada and try again, is potentially a TRP, a temporary resident permit. But that is for another discussion. So let's keep diving down. So agencies, like Ronalee said, are designed to help you in situations where you don't have any other pathways, but your factors and these certain factors that we're going to talk about are in play. Okay. So next part, Ronalee, who is eligible to apply for an H&C?
So anyone who is in Canada is eligible to apply for humanitarian and compassionate application. They don't need to be in status. In fact, most people who make H&C applications don't have status. For applications in other circumstances, including those from outside of Canada, there has to be an application for permanent residence because you can't apply for I want to call it a standalone application from outside of Canada. So it has to be in conjunction with an economic class application or a family class application or some other sort of application. But there are two specific exclusions. One is you can't use it to avoid the lottery for the parent and grandparent sponsorship program. And for express entry, you can't use it to get around being invited to apply through express entry. So for any of the programs that are run through express entry. And then there are also exclusions for people who apply from inside of Canada. And there's a whole list that's available on the immigration website. And a lot of those things are connected with people who have previously made refugee claims. So if you've made a refugee claim and it's been denied, unless one of the exemptions apply, you're not allowed to submit a humanitarian and compassion application for the first year. And there's also other people who can't apply. For example, if you're inadmissible to Canada because of security concerns, significant security concerns, they're not going to let you make a humanitarian and compassion application to overcome them.
Makes sense. Okay. So that's basically at a high level in terms of eligibility. We will dive right into the specific factors that the government looks at. But before we get there, what I want to touch on is the chances of success. And this is important to talk about because people, they don't understand that it's not like express entry where if you get an ITA and you submit your application, it's going to get processed unless you screw something up. In this case with H&Cs, not necessarily the case.
Right. And it's interesting that you use the term, it's going to be processed. The way the legislation reads is that for applicants in Canada, an immigration officer must consider the humanitarian and compassionate factors. So they at least have to look at it. But for applications that are made from outside of Canada, the legislation says may. The officer may consider humanitarian and compassionate factors. So they don't even have to look at it if they don't want to, even though you've done this beautiful set of legal submissions and provided all of these wonderful supporting documents. They can just go, I don't care. I'm not going to look at your H&C submissions. And nobody's obligating them to do that.
Yeah.
So that makes it really hard when you're telling people, well, your chances of success are, well, if they don't even want to look at it, your chances of success are nil. For inside Canada applications, we do have some data. The Immigration Department does not publish success rates. So the only way we know what the percentage chances are is when people do access to information and privacy requests to the government to ask them what the percentage success rates. So sometimes our academic colleagues will do that. Sometimes a journalist will do that. Sometimes migrants' rights groups will make those requests. So the last data that I have seen was published in 2022 by two professors at the University of Ottawa. And they published data that was up until, I think it was the first quarter. I'm just looking at my other screen, the first quarter of 2021. So that's quite old now, but at that point in time, it looked like the acceptance rates for applications from within Canada had decreased significantly over the last couple of years and was estimated perhaps as low as 30%. So that really isn't very good. A couple of years ago, I used to tell people, well, you probably have about a 50-50 chance. But the 50% of people who are denied include people who really shouldn't have been submitting an application to begin with. They didn't have legal assistance, or they didn't have very good legal assistance. They didn't have the documents really to back up their submissions. And so those ones, maybe rightfully should have been denied. So 50-50 chance, if you have a good lawyer and a strong case, well, really your chances were probably better than 50%. But now I don't know what to tell people.
Yeah.
And I have to be really, really frank with people that I don't know how their application is going to be treated. And they could go through all this stress and spend all of this money and spend all of this work giving me the documents that I want and not being successful in the end. So I have pretty frank conversations with people about whether they really want to start this process.
Yeah, exactly. And I want to try, I'm not sure if I can do this. I actually want to flip my screen around. You might bump off of here, Ronalee, but I'm just going to try to see if I can make this work. Oh, let's see if we can add in.
This is something else I wanted to talk about for sure.
I'm going to add in Ronalee here. Okay, you're with me. Okay, so I wasn't going to share this, but I think it's important for people to realize that, the government has annual levels plans, and we talk about this all the time in the context of express entry, all the time. But we rarely talk about it in the context of an H&C. But if you go down here and we look at the levels plans, and these is for 2024 to 2026, and you can see the immigration categories here. If we go down, yes, we know that there's, economic immigrants. There's a large number, right, of those. But when you start to go down here, you'll see near the bottom, under the, refugees, protected persons, we have humanitarian and compassionate applications right down here. And you see how many are here?
Yeah, but it's not even, Mark, it's not even H&C applications alone. It's H&C and other. So there's a couple of other very small programs that fall in there. So you see where it says it includes some admissions from Canada's response to the situation in Afghanistan. And I believe that category probably also includes individuals who have held temporary resident permits for the required period of time.
Exactly. And you can see it right there.
For permanent residence, yes. So it's not just H&Cs, standalone H&Cs that fall in there. It's a few other things. Now, I would imagine that H&Cs are the bulk of it. But the important thing is to highlight the number in column right here. Yeah, so that's next year. That's 2025. And if we could also look at 2026, you'd have to scroll over.
Yep, we can slide over. So that's 2025. So that's that number,
right? So this year, it's 13,750 people. That's not even applications. So if an application is for a family of 4, they're using up 4 spots in that 13,750. For 2025 and 2026 is 8,000. So it's been cut in, not quite half. And I have yet to hear anything from IRCC about why that number is being cut.
Well, it's going to be very, very interesting to see how this plays out, but this will have a direct impact on people who are looking to apply for these humanitarian and compassion applications. And one of the main things that we're focusing on too, in terms of the levels plans, is if they have genuine, eligible H&Cs, they can't just refuse them because we've got too many, so I'm not going to approve it. They actually has to be refused on its merits. But going forward, what we do know is that if they are only allowing, say, 8,000 next year, and there's 10,000 in the queue or 20,000 in the queue, whatever it might be, the one factor that's going to be impacted is processing times. So we haven't really talked about that too much, Ronalee, but what are you seeing in terms of how long it takes to actually get a humanitarian and compassionate application adjudicated?
Yeah, but Mark, before we talk about that,
Hmm.
I just want to step back. So the
Sure.
paper that I was talking about by the two professors from the University of Ottawa talked about the fact that the denial rates have gone down as the number of applications have gone up. So I completely agree with you that humanitarian and compassionate applications are supposed to be determined on the merits of the case. And if someone doesn't like the decision that they get, they can apply to the federal court for a review.
Yeah.
However, we can't help but notice the correlation between the increasing number of applications and the increasing number of denials. And these kinds of applications are completely discretionary. What you said earlier about an express entry application, that so long as you submit your application with all of the required documents and your letter of employment meets the required standards, your application is going to be improved. It's not like that for humanitarian and compassionate application. The officer who looks at it could say, yeah, I don't think this is enough. Another officer who looks at it could say, yes, I believe this is enough. But if they're under incredible pressure and they know what the levels plans are, what used to be enough may no
Yeah.
longer be enough, right?
Yeah.
And because they're so highly discretionary, when you go to federal court, so long as the officer has justified their reasons, then the
Yeah.
federal court is going to say, well, I'm sorry, but that was a reasonable decision. They said why they didn't believe that there was sufficient humanitarian and compassionate considerations. And not a lot of people can afford or want to appeal to the federal court, or they're being, required to leave Canada. And then once they're gone, they just, they've lost their establishment in Canada. They've
Yeah.
lost a lot of other factors. So I hear what you say in terms of processing
Yes.
times increasing, but if they just start denying more applications, the processing times may not increase that
That's
much.
a good point. Yep. That's a
Yep.
good point, Ronalee. Absolutely. And
So
ultimately, the yeah.
yeah,
Go
the
ahead.
current processing time on the IRCC website is listed at 20 months. But I can tell you that I have clients who are currently at about 19 months, and we don't even yet have a decision on the first stage of the application. And then I can talk about the two stages of processing. I believe we're going to talk about that in a minute. So we're very close to the listed processing time, and we've had absolutely no movement whatsoever on the application for two of my files. And I've heard of colleagues who have other applications that are sitting at about the same time frame. So it looks like processing times are going up for sure.
Yeah. Now, I want to bring something up here from Talia. And she says, if the HNC is refused, can the person apply for refugee status? And so I want to narrow our vision of who's on the other side of this camera, Ronalee, to people who by and large are here working, looking for a way to stay. And, so they're looking for any avenue. And you know as well as I do that there's these bloody representatives out there who are just looking to make a buck. And so they'll tell Talia, hey, let's file an H&C. I'll charge you $10,000 for it. Real cheap, but these are tough applications. And then they'll do a garbage job. It'll get rejected. And then Talia will say, well, it got refused. The representative says, oh, yeah, sometimes that happens. But we can file a refugee application now. Can they? And even if it was an option, does someone want to do that? And I'll qualify that with, we're not giving any legal advice here. These are just generalities we're throwing out. But can a person, after they get an H&C refused, apply for a refugee application? Any restrictions on that?
So having an H&C refused does not impact your eligibility to make a refugee claim. The eligibility to apply for refugee protection in Canada has its own set of eligibility criteria. If you already have a removal order issued against you, that's one of the reasons why you wouldn't be able to apply for a refugee claim. But just because your humanitarian and compassionate application is refused doesn't necessarily mean that a removal order will be issued right away. However, I can tell you, as someone who does refugee claims, that if you have a humanitarian and compassionate claim denied, that is something that the Refugee Protection Division will consider when determining if you have subjective fear, so whether you're really afraid to go back to your country, or if you're just trying to find any way you can to stay here. And a refugee claim is determined on its own merits. They look at the Refugee Convention, which is international law. It's not just Canada's law. Canada has incorporated the Refugee Convention into our immigration laws. But there has to be a reason under the Refugee Convention to seek protection, and you have to be able to prove that if you went back to your country now, you'd be at risk. So refugee claims are also very, very quite difficult.
Interesting. All right. So, and I know a lot of people, who watch this are trying to figure out, okay, well, what is this actually going to cost me? If I'm looking at applying, what's reasonable in the circumstances? And that's not usually something that we talk a lot about, but it's really critical. And you and I, Ronalee, had this discussion before when we were preparing for this. It's critical that us as representatives, as immigration lawyers, are very, very open and transparent with people. One, about the chances of success, obviously with how much we charge, but the combination of the two, and whether or not it's even worth it to do that and toss that money away that could be used to help you get resettled back in your home country. And I'm going to be doing some future episodes here within on the Canadian Immigration Institute, and we're going to specifically address and talk about some of the benefits of actually going home in the context of express entry, which a lot of people, I don't think they understand, the impact it can have positively when you go home and get more work experience from home. But that's an entirely different discussion. So, okay, do you want to tackle this one, Ronalee?
Well, I think, how much immigration lawyers charge. Some lawyers charge hourly. So if you're the kind of client that never answers your lawyer's emails, and you have to get asked 6 times before you provide documents, and you provide screenshots or JPEG files, of individual pages of a document, and it takes a lot more work to put everything together, your application is going to end up costing more than it would for someone who's paying hourly but is really efficient about providing information and gets the documents in a timely fashion and in a PDF that's readable. Other lawyers will charge a set fee, and that set fee will vary across the country and with the level of experience with the practitioner. Like in some areas of the country, it is just more expensive to practice in terms of law society fees, rent for offices, things like that. And it will also depend on how many people are in the application. So, I'm not going to charge the same for one single individual that I will for a family with 4 children, 2 of whom were born in Canada, 2 of whom were born outside of Canada, and how much work it's going to require to review the person's immigration history. So if I have someone who's a failed refugee claimant, they previously did it in H&C that was denied, they tried to apply under express entry and that was denied, and they've been in Canada for years and years, and I've got to read through pages and pages and pages of previous applications and notes that officers wrote in the in GCMS notes in the electronic system where they keep notes. I'm going to want to charge more for that application too, just because it's going to be a lot more work. But what I tell people is that I charge more for humanitarian and compassionate applications than I do for any other kind of application, because it is the most amount of work that I will ever spend on a single application. The submissions that I write that accompany humanitarian and compassionate applications usually range 15 to 20 pages. I provide hundreds of pages of supporting documents, all collated, title pages, letters of explanation. And just gathering those documents takes a really long time. I also do affidavits or statutory declarations for every adult claimant, adult family members, immediate family members in Canada. So they all require multiple meetings. I have to commission their documents. So they take a really, really long time. So these are incredibly expensive applications, at least as far as I'm concerned. And that is why I tell people, are you sure you really want to do this? Are you sure that the money that you're not going to spend on me and the government application fees, which is, $1,300 just for a single applicant, times that by multiple adult applicants, you're looking at a very expensive application. Could you take that money and go home and start a business or something like that? So,
yeah, that's a great explanation, Ronalee. And so this is my opportunity to teach. And one thing I will tell you guys is that if after what Ronalee told you, the efforts that she puts into an H&C application, You retain someone to assist you, and they send you a questionnaire, and they never hardly even meet with you at all. They never ask any detailed questions other than whatever was in the initial questionnaire. And they're prepared to submit it without you even hardly seeing what's in the application. Please understand that there's going to be a huge difference between how that application is processed and, for example, an application that Ronalee or experienced immigration lawyer will have filed. Or, and there's some really good immigration consultants out there too. But you can tell right away if they are really, really invested in it, because each one of these applications is unique to you. And the things that are included in some other person's application may not apply to you at all. And so going on your immigration forums or trying to get strategies and tips from, any online resource or crowdsourcing of information can be very, very dangerous, because each of you have your own story to tell. And as we transition to the actual things the government looks at, the things that can really help to lead to a positive decision, you'll see that they're very unique to you. And whenever there's uniqueness in an application, Ronalee and I, we can't, there's no economies of scale. Just because we did something with one person doesn't mean we just copy and paste it and used it with another person because they're from the same country. And so because of that, that really tailored approach, that really custom approach, it's expensive. And if someone is offering to do it dirt cheap and they are not engaging with you multiple times in in-person visits or Zoom calls or whatever it is to gather information and strategize, then you probably hired the wrong person, because this is a lot of work. And if you want to be successful, not only do your facts have to fit the equation, but they have to be presented in a positive way. So so pay close attention to that. Now, I want to just pull up just a few little comments here. Talia says, thank you so much. You're very welcome, Talia. And I'm going to pull this one up. And Marco says, how has immigration changed from Harper to Trudeau? So basically from the Conservatives to the Liberals. And, you could go through a whole laundry list of different factors that are, that have happened as a result of each differing political parties' policies. But to a large extent, it's global circumstances that drive a lot of this stuff. But I could say, if I could say, okay, well, what is the one difference for me between Harper and Trudeau, how has immigration changed per se, is the demand for Canadian immigration, Canadian permanent residence, Canadian study permits and work is astronomically higher than when Harper was the Prime Minister of Canada. And so whenever you have massive volumes of people and a high demand to come to Canada, then it's going to affect all kinds of processing, not just processing times, but it's going to put all of you in the situation that you are right now, with very limited or no options for permanent residence after spending thousands and thousands of dollars, time, effort, dedication to go to school, to come to work. And so that is one of the main differences. And express entry was in place when Harper, just before he transitioned out and Trudeau took over. So that was in place, but it was a different world, my friends, a different world. And if you go back and look historically at the rounds of invitations, you will see how much lower those scores were. And of course, what else is different? The Liberal government has prioritized different things compared to what Harper and the Conservatives prioritized. And I know many of you are asking, well, what if there's a party change? What if there's elections and things change? Well, what is that going to mean for me? Well, Ronalee and I can't answer that question. We have no clue really what's going to happen. But the reality is right now, right, things are shifting. Things are becoming more difficult. So I wanted to address all the questions that were asked. I don't know, Ronalee, if you want to wade into that at all and offer your thoughts about the differences between, between the two prime ministers with respect to immigration changes.
Well, as for humanitarian and compassionate situations or applications and how it's applied, that has not changed at all. The legislation has not changed. The programs have not changed. The only thing that's changed is some of the exclusions in terms of when you could use humanitarian and compassionate factors, and the express entry, not being able to use it to get around being drawn from the pool, and for the parent and grandparent programs. Those are the only recent changes. And also for humanitarian and compassionate applications, they're not driven by policy by the governing party, whoever's in power. Those decisions are made by individual immigration officers. So yes, If they've been recently hired and recently changed, maybe the government that's in power and the kind of training they're getting might be different. But if you've got an officer who's been working for the immigration department for their entire career, they would have been trained under a previous government. So remember what I said earlier about how these applications are highly discretionary. They're the most discretionary applications that exist in our immigration system. So I would suspect that the people who make those decisions are less influenced by whoever's in power. That would be my guess.
That's a great response, Ronalee. Great response. Okay. Now, here's where we're going to teach you exactly the things, well, exactly, generally speaking, what the immigration officers have been directed to pay attention to in the context of your H&C application. And so you can see here, I'm gonna pull this off and I'm gonna pull up this comment. Look about well timed here. Leon says, what factors can be considered for H&C? And so let's flip over here. Ronalee and I are going to slide over here, and we're going to look at the key things that IRCC focuses on. So humanitarian and compassionate factors, right off the bat, start with this: establishment in Canada.
Are you making that noise? That's very cool.
Yeah.
I didn't realize it was going to ding like that. So, of course, this factor is only important for people who are already in Canada. Obviously, we're not going to use this factor for an application for someone who's not inside Canada. So, establishment in Canada means, are you working? Have you worked consistently since you've been here? Do you have family here? Are you involved in a faith community? Do you do volunteer work? Do you belong to a gym? Do you have friends? Are your kids in school? Are you in school? All of the things that people do to get themselves involved in their community and involved in Canadian society. If you're the kind of person who, goes to work and comes home and has no friends and has never done volunteer work, has never joined a community organization, you have no friends or family here, other than maybe your job, you're really not going to have any establishment in Canada. So it's the people who would be missed if they left Canada who have establishment in Canada. The people who, if they left their job, it would be really hard to replace them because they're just such a wonderful team player, because they have such good skills. It's the people who belong to a faith community, who help out at services that people are going to miss. Things like that. That's what they're looking for when they look at establishment in Canada.
Yeah. You're a fantastic football player, from South America, and you're here and you're coaching youth soccer, right? Like those kinds of things. Well, if you deport me, all these awesome kids, these 15 kids and their parents on my team, well, they're not going to have a coach anymore, right? Those are meaningful things. Yes. And people don't think about that. But in fairness, Ronalee, it's easy for us to say, hey, you should volunteer and do all these things when we know what you guys are going through. In many cases, when it reaches the stage of you applying for a humanitarian and compassion application, often you've run out of options, or something has happened catastrophically in your family or with your health, or something that's, just made it almost impossible to work, let alone volunteer. So we're mindful of those things. Yes.
Yeah.
Ronalee.
And it's only one factor. We're going to have a whole list.
Yeah, we are. This is one. So the more you can hit, the more you can specifically address, the better off you're going to be. Okay. Yeah. Next on our list, ties to Canada.
So I've always had difficulty with this because ties to Canada and establishment in Canada are, very similar. But I guess with ties to Canada, what they're looking at more is family in Canada, agency basis if you are well established in Canada.
Yeah,
yes.
People are posting their comments here. Sure, it's all good. Yeah,
exactly.
Slide this over a bit.
Yeah, so I think that these two factors are very similar, but family ties, that would be an example. But it wouldn't be enough just to have family in Canada, right? If you don't ever spend any time with that family and they barely know you, then you haven't established yourself in your family community as well, right? Like, oh yeah, I've got some cousins who live a couple provinces away, and I like their pictures on Facebook. Well, again, you could do that from your country of citizenship. You don't have to do that from within Canada. So I think that's sort of what they mean by ties to Canada. I sort of waffle between the two when I'm doing
Yeah.
submissions for free.
And as we get to other factors, we'll hit on this, which with a more direct attention. But people sometimes feel if I come and I have a child here in Canada, they're born in Canada, that's going to guarantee me the opportunity to be successful through this HNC, because are they going to let my Canadian born child come back with me to a country where maybe the conditions are not as good as they are in Canada? And so it's Ronalee, what are your thoughts on that? Although we will dive into a little bit deeper here in a second.
That exact situation happens all the time because they say, well, you don't have to bring your child back with you to your country of citizenship. You
Yeah.
can leave them here.
Yeah.
They can stay with the other parent if that parent has status in Canada, or they can stay with another family member, or you can even put them in foster care if you want. That is not enough. That tie, having a child born in Canada, is not enough in all cases.
Gotcha. Give a shout out here to Joe. He says, hey, Mark. Hey, Ronalee. Great to catch the stream. Thanks for connecting in, Joe. All right. Number 3 on the list, best interests of children. So let's dive into that.
That brings us right from what we just talked about to best interests of children. So the best interests of children is a factor that is specifically mentioned in the legislation. It basically says, and I'll actually, if you don't mind, I'm actually going to read from it because I think that's the best way. So it says that the minister must consider, examine the circumstances concerning the foreign national and may grant the foreign national permanent resident status if the minister is of the opinion that it is justified by humanitarian and compassionate considerations relating to that person, taking into account the best interests of a child directly affected. So it's the only factor that's specifically listed in the legislation. And the courts have looked at that and they have said that although best interest of a child is of high degree of importance, it is not the only factor and it is not enough on its own. So even when we talk about the best interest of children, there still has to be circumstances which are somewhat extraordinary. And that's a very loaded word because the federal court has bantied around with the word extraordinary, but it's not for every case where the best interest of the child will be sufficient to grant the applicant permanent residence in Canada. So we'll look at cases where the country conditions are such that the child would be significantly adversely affected. So, for example, recently I read about a case where there was a child who had asthma, pretty bad asthma. And before he came to Canada from India, he had to use puffers and a lot of medication to help him with his asthma. But when he came to Canada, his asthma was a lot better. And so one thing that was put into the humanitarian and compassionate application was that this child's health was going to get worse if he had to go back to India. And the person who made the decision said, well, with climate change and wildfires, conditions in Canada aren't that great either.
Love it.
Thankfully, and that was actually one of the first cases where climate change was, sort of indirectly brought into a federal court decision on humanitarian and compassionate considerations. Thankfully, the federal court said, I really think you need to look at this a little bit more thoroughly than what this officer did. So they sent it back for another officer to look at because you still couldn't compare the level of air pollution in India to a bad wildfire day in Canada. So that's an example where the best interest of children, it wasn't just, well, yeah, life in Canada is better for this child. It was his health would be affected. And that was why it was in his best interest to stay here.
And one thing I'll add, another example, because I think this is where people learn, and we'll give a shout out here to Celia. This is where people learn is from actual scenarios, right? And so I'll give you another example. So one of the factors in my TR to PR, because I've done a couple of these through HNC, but in this case, it was a Filipino woman who was here, and she was single, but she had two sisters back in the Philippines that were still on the family farm. They had, with all their children, they each had, I think, 4 and 5 kids themselves. And because of the work that this my client was doing in Canada, she was sending money back to them. And so they were able to access healthcare coverage that they wouldn't otherwise have been able to benefit from, as well as go to schools that they wouldn't have been able to go to otherwise. And so you have to understand that when it comes to the best interests of children, it's not necessarily just the children that are here in Canada at the time. And many people don't understand that. And so we put in a lot of evidence to show the money that was sent back and forth, the actual records of, the school records for the kids, the fact that they were doing well, excelling, they had clothes, and they weren't a well-off family by any means, but because of what she was doing here. And with the TR to PR pathway, like I said, she wasn't going to have a path forward because she wasn't eligible. But because of the humanitarian compassionate factors that directly affected the interests of these children, we were able to get it approved. So that's a very positive scenario.
So the child could be the applicant themselves. The child could be a Canadian child whose parents are the applicant and might be deported. And then you're right, it can be any child who's affected by whether or not the person applying for permanent residence gets granted that permanent resident status. So I recently did an application again for a single woman, but she had a number of great nieces and great nephews in Canada. And it was a very, very tight family. They often got together, 30 of them would often get together, cram into a house and have dinner together. And, it was very important for her nieces, great nieces and nephews that she be allowed to stay here. So her application was approved as well.
Very cool. All right. So Writer K says, hi, Mark and Ronalee. The case about a child from India that Ronalee just discussed would also apply in reverse. Example, if a senior parent has no one back home to take care of her and has a child in Canada. All right, Writer K, you got to hold your horses because we're going to get to this. So let's take a look at a few other factors here.
Yes.
All right. Adverse country conditions. So, and you will see, you guys, that these start to blend in together. All right. Because what could be considered, an issue that's in the best interest of a child could also have overlays with things like adverse country conditions or ties to Canada or establishment. So these are really interchangeable and you have to weave them together.
Yeah.
All right.
The new buzzword for that, Mark, is intersectionality.
Intersectionality. Love it.
Okay. So adverse country conditions has intersectionality with refugee claims as well. So it's specifically stated that officers who are determining H&C applications may not consider risk in their analysis. So I can't put in an H&C application that my client will be killed if they get returned to their country of origin, because that is more properly part of a refugee claim. However, a lot of adverse country conditions and risk factors in refugee claims are almost the same. So if you were going back to your country and your children were at risk of kidnapping, and so you would never be able to send them to the park to play like they can in Canada, and they would have to be driven in an armored car to school, or maybe they couldn't even go to school because it would be unsafe. It's not in the best interest of that child because of the adverse country conditions that child would have to live in. This is how we get around sort of not being able to discuss risk as we talk about adverse country conditions. But adverse country conditions can mean all sorts of things. So the client I was just talking about who had great nieces and great nephews in Canada was from Lebanon, where right now it is very difficult to get prescription medication. You can have all the money in the world, but if there's no medication in the store to buy because they can't get shipments in, and you have a medical condition, then that's an adverse country condition. So is the availability of food, regardless of the amount of money that you have. So there's lots of different things that can come into adverse country conditions that could affect you. They have to look at what circumstances you would be living in if you returned.
Yeah. Shout out here to Marco. Thank you, my friend. He said, "Thanks, Mark. You always provide detailed answers. Starbucks on me." Well, that's kind. I'll have to share that with Ronalee virtually.
Okay.
All right. Okay. So next on our list, let's see if I can make sure I'm hitting the right buttons here. Health considerations, which really, to some extent, I guess, overlap, like you said, with adverse country conditions and everything else. But, you
Right.
know,
So that's, again, availability of healthcare, availability of medication, discrimination. So, for example, if you're someone who has HIV and, oh, yeah, well, maybe you can get treatment. But, if you go to the doctor, it means everyone's going to be told that you have HIV, and that's going to make it hard for you to get a job as a result. Privacy in the healthcare system is also something that can come into health considerations. Here we take it for granted that doctors aren't going to spread information about our health conditions, but
yeah,
maybe that's not going to be the case somewhere else.
yeah,
So all aspects of medical care can come into these kinds of applications, and you have to be creative. You have to do your research. You have to get proof that the person has a health condition or a mental health condition. Perhaps they come from a country where they have a mental health disorder and they're going to be considered a witch, right? And they're going to be, discriminated against because they have a mental health condition. So that's something else to consider. We're not just talking about physical health, we're also talking about mental health here.
absolutely. Yeah, I had a little visitor who popped by there, who my wife just got home, and he was absolutely bent on going to greet her. So he was going to attack me unless I let him through. So Simba once in a while makes appearances on the live streams too.
Am I allowed to do a
Okay.
show and tell too? I've got two of them sitting here right at my feet.
Yes. That's life. That is our joyful life now. All right.
All right.
This
Maybe they'll make
this
an appearance between now and the end of the show if they wake up.
Yeah, absolutely. Everybody's welcome. So, Music Without Borders here says, "Hey, Mark and Ronalee, thank you for taking the time and to discuss about this topic. I just have a question. Will you lose eligibility for express entry if you have sought protection?" Now, I'm going to clarify so everybody else knows. Protection is, synonymous with a refugee claim. So,
Yes.
Ronalee, do you want to? Then this is different than a humanitarian and compassion
I can answer
application.
that question, no problem, because I do humanitarian and compassion applications, express entry, and refugee claims. So I've got it all covered. So when you make a refugee claim, you are issued a removal order. That removal order, or deportation order, is stayed, so it's not enforced until your refugee claim is determined. If your refugee claim is denied, then they enforce the removal order and they kick you out of the country, theoretically, anyway. Anyone who has a removal order no longer has the kind of status in Canada that you need to gain Canadian experience for the purposes of calculating your comprehensive ranking system points. So, will you lose eligibility for express entry? You don't lose eligibility, but any work that you have after the point you claim refugee protection is not going to be counted anymore. Um, but the work that you did before you claimed refugee protection could still be considered. The only problem is that you do have a removal order. So if you get invited to apply for express entry, you can't become a permanent resident from within Canada. You have to leave Canada, go somewhere else to another country, and then you can come back with your approval under express entry. And that is something I clarified with the Immigration Department in about 2016, very shortly after the Express Entry program was started, because I had a refugee claimant who was a nurse, and I had applications going for her under both the refugee stream, and I put in an Express Entry application. So,
Excellent. 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 All right. I think there's one thing in order for that response, Ronalee. Yeah, we'll give you a round of applause for that one because people, I can tell you that the vast majority of even representatives do not know that. They don't know what
mhm.
you can and can't do in the context of a refugee
Yeah,
claim as it impacts other areas.
I have a kind of a unique practice area. As immigration lawyers, we tend to do humanitarian work, refugee work, family sponsorships, or economic immigration, which often can include helping businesses. And I I have this mix where I don't represent businesses, but I represent individuals and family, and that includes refugee claimants. It also includes private sponsorship of refugees, which I've been on the show before. So, I belong, unfortunately, it means I belong to 3 different listservs
Mhm.
and end up reading hundreds of listserv posts a week just to try to stay on top of things, because I have to read all the ones for the refugee lawyers and all the ones for the other, the economic streams as well. So it's a bit more work, but
I did a little
is
Search Canadian Immigration podcast, Ronalee Carey, and here we go. We had our private sponsorship of refugees. You were episode 29 and episode 51. I think we're at, I don't know, 130 or something now. But yeah,
that means I get
yeah,
to come back in 75 more episodes.
absolutely. It's time. Well, do you know what, Ronalee? This actually is going to be a podcast episode that we're going to convert it. So we're going to make this one a podcast episode as well. All right, let's jump back into here. So just if those of you who are just tuning in and connecting in, this is a discussion. It's all about humanitarian and compassion applications. And basically when everything else fails, sometimes this may, in very, very limited circumstances, be a possibility for you. But for some people who are just not aware of it, you could lose out on an opportunity to actually stay in Canada as a permanent resident when, or maybe if you weren't aware of some of these factors. So with the factor list, let's go back here and let's continue on. But I'm going to address Salia's question here, Ronalee. Can all of these factors be lumped in an H&C, or you have to pick what applies to you and build more evidence on that, or all these factors can basically come into play in an H&C application?
Right. So when I do legal submissions, I address each factor individually. I also talk about judicial decisions that have reviewed those particular factors as they apply to the case. And I discuss each piece of evidence that I have that relates to that particular factor. So, yes, I lay it out one by one. The immigration website, their instruction manual for officers, lays these things out. We're not making these up. These come from the instructions for officers, right? Because the legislation just says we can look at humanitarian and compassionate considerations, or the officers can't. So, other than the best interests of children, the legislation itself doesn't lie out each of these factors. This comes from the processing manual that instructs officers how to determine these applications. So the goal is to make it as clear as possible for the officers of how they can positively exercise their discretion. And the more things that you can tell them, look, it fits this, it fits that, it fits this. Look how many things that the policy manual says you're supposed to look at, and they all apply in this case. You definitely should consider this worthy. So yes, I'm not going to lump it into all together. I'm going to idiot proof my submissions as much as I can. That's what I like to call it.
Perfect.
Make it
Colette
simple.
has a Yes, Colette has a question here. He says, "Is discrimination based on ageism, a factor when it comes to something like employment?"
Absolutely. That would be considered an adverse country condition. But I wouldn't just say that. I would find articles that talk about either newspaper articles or social science research or academic articles, statistics that talk about ageism in the workforce in that country. I wouldn't just say, oh, well, they're this old, they're going to have trouble finding a job. And I wouldn't rely on my client's statement that that was the case. I would be finding evidence, empirical evidence, to back up that statement.
Absolutely. All right. Okay, let's continue on with our list of factors. So we're on number 6 here. I think this is 6. Let's see. I can test this. Yeah. Okay. Number 6. Here it comes. There's number 5 again. There's number 6. Family violence considerations.
Right. So that, especially for individuals who are in Canada, they will actually even process applications on an expedited basis. So I'll give you an example of where this could come in. So, husband and wife and children come to Canada. The husband and the child are already Canadian citizens. The husband because he was born here, the children because their father was born here. They come to Canada. The wife has a visitor, comes as a visitor, and the husband says, I'm going to apply to sponsor you for permanent residence. And then there is an incident of domestic violence, and the parties separate, the husband and wife separate as a result of that domestic violence. And so because they're no longer living together, even if the husband wanted to sponsor the wife, he can't, because they have to be in a genuine relationship and they have to be cohabiting. So what does the mother of the children do at this point in time? Her children are Canadian. If she goes back to her country, maybe she won't even be allowed to take the children with her. Maybe the father will go to court and say, well, no, that's not a good country for the children to live in. That's why we came to Canada to begin with. And then, so the mother has to leave her children. That doesn't seem fair at all, and not even perhaps safe for the children. So family violence considerations is something that the officer can look at in addition to best interests of children, in addition to adverse country conditions, specifically to allow women or other victims of domestic violence or other types of family violence to be allowed to stay in Canada.
Yeah.
And that also is the case for dependent children of people who are here in Canada as well. So, for example, an 18 or a 19-year-old, so they're still considered a dependent child, and they came with their family. They're here as temporary workers, and there's child abuse in the home. So, and I've seen cases like that, not myself, but one of my colleagues here in Ottawa who works at a legal clinic had a case like that, where she was representing a young woman who needed to leave the family home because of child abuse and wanted to get her permanent residence in Canada because she was a woman who couldn't really live in her country as a young single woman.
Yeah, exactly. And there's all different kinds of factors that can come into play too. I've got a client right now that we're in the process of filing an H&C application for, where it's a situation of domestic abuse, and the children are Canadian, and the soon to be applicant is a foreign national, and the spouse, unfortunately, is, they didn't take steps to do the sponsorship when things were, more pleasant, I guess, in the relationship. But, now, unfortunately, it's the agency is the natural route. And I'll be honest, Ronalee, like you said, I have no doubt that the agency application is going to be approved in her situation. But yeah, family violence absolutely is a huge factor. Okay. Next, consequences of family separation. And you've kind of hinted on this a little bit before in some of the, in the context of some other factors. But what are your thoughts on this one?
So, again, there's intersectionality between ties to Canada, establishment in Canada, and the best interests of the children. But what we're looking at here is how a family, either an immediate family or an extended family, is going to be affected by someone being deported. So, for example, if you have a mom and dad and they're both contributing economically here in Canada to the children's welfare, paying for extracurricular activities, a nice place to live, groceries, healthy food. And one of the parents is going to be sent back to a country where they're not going to be able to earn very much money, and they will barely be able to survive, much less send money for their children. That's going to be a consequence to the family. So it will affect children, but it's also going to affect the family's ability to be self-sufficient here in Canada. Maybe they'll have to get welfare assistance, who knows? So that's one example. But we're also looking at, for example, I have a case right now where there's a family member who has mental health concerns, and the foreign national is a family member who is providing a significant amount of support to that individual. So if they lose that support, it's going to affect that adult who has mental health considerations. That person helps take them to medical appointments, lives with them actually, so provides day-to-day care in terms of grocery shopping and cooking and things like that the person with mental health condition just can't do for their own. So the consequence of separating them from their family member in that case is going to be pretty significant to the Canadian. So again, there's all sorts of things that can come in here. It's really going to depend on the circumstances and the circumstances of the Canadian family members, but also the circumstances of the person who's going to have to leave.
Yes. All right, I'm going to pull this one up, Ronalee, just really quick so that people that are watching can understand. So D. Samuel says, "Hi, sir. Can I apply for my mother under H&C who is currently in Canada as a visitor? She's 80 years old and no other children and widowed." So anytime we have these types of questions, I always ring that little bell. And that basically means, hey, if you need direct assistance like this, because Ronalee and I can't tell you whether or not you may or may not be eligible for HNC. There's definitely factors there at play that may justify to some extent a humanitarian and compassion application. But what I want to always do is just slide over here, and in the description we have a link to Ronalee's site where you can connect and schedule a consultation with her. And so there's a link below in the description, and I'd recommend Samuel that you consider doing that.
Right. But I would like to make one comment. Samuel said, "Can I apply?" There's a difference between "can I apply" or "if I apply, will my mother's application be
Yes.
accepted?"
Yes.
So, can a visitor apply for an HNC application? Yes, they can. So that answers the can question, and that's not legal advice for Samuel directly.
No.
I'm not sure if Samuel wants to know, can he, or will the application be successful? Whether or not the application will be successful is going to depend on a lot of things. Have I been successful for a widowed mother who's 80 years old? Well, maybe not exactly 80, but yes, I have. But what country are we talking about? Are there any health considerations? Are there any grandchildren here in Canada? These are all the things that you would have to canvass in an individual consultation.
Yeah. All right. Okay, let's jump to next on our list, inability to leave Canada.
So this is a really interesting one. And I think, what IRCC is getting at here is you could have left Canada, but you couldn't for reasons outside of your control. So, for example, there was a pandemic and there were no flights, and you couldn't leave by car or plane or boat or train. And so, as a result, you spent an extra 8 months in Canada. And during that 8 months, something happened that was different than the 8 months previous. And now you've had a child, you've gotten a new job, who knows what could have happened. And as a result of that inability to leave Canada, you've established more, ties to Canada. You've got more establishment in Canada. So it's not like you stayed in Canada for all this time just because you were hiding out here and living, without status and working under the table. It's that you really weren't allowed to leave. Another example would be people who can't be removed from Canada because of the circumstances in their home country. So, for example, right now, we don't expect anyone from Ukraine to return to Ukraine. There is actually a directive that, with the exception of significant criminality, maybe that'll be different, but we do not return people to a listed number of countries through either an administrative deferral of removal or a temporary, oh my God, I can't remember the other one. Anyway, there's two different types.
Moratorium sorts.
Moratorium, yeah. So moratorium countries, there's two different lists, and I can't remember off the top of my head, but one is meant to be more temporary than the other. The other one is we recognize that conditions in that country are probably not going to change for many, many years, so they go on a different list. So you may have lived in Canada for 10 years because after you got to Canada, there was a war broke out or something else happened, and we don't expect you to leave. And during that time period, you did all sorts of things to become established in Canada. And so the fact that you stayed in Canada, even though you really weren't supposed to be here, isn't something that's supposed to be taken against you.
All right. Number 9, ability to establish in Canada for overseas applicants.
Right. So if so for example, you're not allowed to sponsor a family member unless they're a member of the family class. Okay. So if you do an application to sponsor a family member and you ask for humanitarian and compassionate considerations to be applied to waive the fact that the person is not a member of the family class, okay? So you're applying to sponsor your nephew, even though you're not normally allowed to sponsor a nephew. That person's ability to get a job in Canada, if they speak the language, if they have a support network that's going to help them get on their feet, Those are all important considerations that they will look at when they're looking at whether or not they can allow the person to come here. If the person's going to come in here, never be able to work, has no family support, is going to require social assistance, then it will be a negative factor in their ability to establish in Canada.
And last but not least, I like this one. Probably my favorite, probably. Unique or exceptional circumstances. So what makes you so special that it's just tough?
So, in the case law, there was this case, and it was a long time ago, but the courts keep sort of bringing up the same remarks from that case. And it talks about whether or not sort of the average Joe in Canada would look at that person's circumstances and feel sorry for them. I'm paraphrasing, but that's basically what it comes down to. Whether a regular Canadian would have compassion for that person and say, you know what, if I was the person making a decision here, I would let them stay in Canada. So I'll give you an example, and unfortunately, this is an example from my law firm's archives that was not successful. But we had an international student who had a very, very significant injuries from an automobile accident, had to abandon his studies, went through rehabilitation for a really long time, and wasn't going to be able to apply as a regular international student because they couldn't get a post-graduation work permit and all these things. But they were well established here in terms of they belonged to a faith community. They had family here. They'd been living here for a really, really long time. And they also wouldn't have done as well medically in their home country. So there were lots of positive factors, and I would have hoped that the reasonable person, my neighbor, might have said, well, sure, yeah, the guy had a horrible car accident and his parents are here and he's been living in Canada for 10 years. We should let him stay. And unfortunately, despite the best efforts of my associate lawyer who did that application, and I reviewed it before she submitted it, and she did an excellent job, it was not accepted because it was a young man who could go back to his country, and he at that point in time was well enough, he could have worked, he could have got a job there. So they said no.
Yep.
So
That is within that's within their prerogative to do.
exactly.
Right?
But we thought that was a unique circumstances.
Yeah.
Like, how many international students who otherwise would have had a brilliant future in Canada are in an almost tragic car accident. It's pretty unique. And so again, it really comes down to individual circumstances and meeting and just going through everything in the person's life and everything that they've done since they've been here and all the circumstances that apply. And then knowing, like, I keep a case law bank. I recently did a workshop for junior lawyers through the Canadian Immigration Lawyers Association. And one thing I shared in my resources was something called, we call it our case law bank. And every time I see a really good case from the federal court that looks at certain factors, like, oh, the person was in a car accident or the person had asthma, these are the kinds of cases that I like to throw in my case law bank. And we keep a good table of contents so that, if I have a case, I can go and check my case law bank, because I really do try to keep, as many relevant cases in there as I can. And then I'll still have to do other research, but it gives me a starting point for these sort of unique and exceptional circumstances.
Here's a tough one. I love asking you. Will undocumented work to support yourself be used against you in an agency context, or play in your favor, assuming you're not able or did not prove it?
Well, if you can't prove that you have the work experience in Canada, then it's not going to play in your favor. So and so you sort of have to go to your employer and say, I know that you've been hiring me under the table and you could get in a lot of trouble for having done that, but will you write me a letter for my humanitarian?
Yeah, look at my ties to Canada, my establishment here.
Yeah, exactly. And here's my, confirm that you've been paying me in cash. And yet we do that all the time. We get those letters from employers. Immigration does not seem to go after employers who provide those letters. And they also will take positively work experience in Canada, even though it was done under the table. It was done as an undocumented work, unauthorized work. However, it's going to depend on the officer, because some officers will say, well, you should have left and you didn't leave, and you worked under the table, and you took advantage. You haven't, you're not coming to this with clean hands. So
Yes.
it really will depend on the immigration officer, how they will decide how to look at that particular factor. It can go either way.
Yeah. But both
But for the
Ronalee,
most part, it's looked at positively, I
yeah,
would say.
yeah. But notwithstanding that, both Ronalee and I would advise all of you to not do that and
Work
work under the
without
table.
authorization.
Yes,
Absolutely.
indeed.
Yes. But we're talking about people who have already done the work without authorization. So
Indeed. Yes. And then
we're
they
not
come to us
talking
and
about,
then we're trying to sort it out. Indeed.
yeah, exactly. They've come to us and they have already been living without status in Canada for a long time. They've already worked without authorization. Am I going to keep out the fact that they've worked without authorization in their humanitarian and compassionate application? No, of course not, because it shows that they have the ability to become properly economically established in Canada. And it shows that they can be financially self sufficient, which is one of the requirements. And in the second step of processing, which is, I talked earlier about how there's actually two steps to processing. One of the things in the second step of processing is showing that you are financially self sufficient.
Yeah.
So you have to provide evidence that you're working or you have been working.
Yeah. All right. Ryder K comes back with one last question. If senior parents, Canadian PR, want their son, who is a refugee in another country, to be sponsored by agency to take care of the parents, would the application have a chance to win?
So again, I'm going to go back to can and will it be accepted?
Yeah.
So can the Canadian permanent residents apply to sponsor their son? So that's a situation where the son is not considered part of the family class for a family class application. You're only allowed to sponsor your spouse, your parent or grandparent if you're selected through the lottery, and a dependent child. So if this son is not a dependent child, then the son can't be sponsored. So they would have to do a family class application and put in humanitarian and compassionate factors. And
We
whether
got a
or not
visitor coming.
they'll be accepted,
There's
again,
our visitor.
look who woke up.
Oh, hello. That is the cutest dog in the world, Ronalee.
He
He's
had his
like,
haircut.
you woke me up. My eyes are they're still blurry.
No, he was pawing at me. I don't know if he wants to go.
He wanted to come up and be a part
I
of
have
it.
2 office dogs because they do, not all the time, but they do come to the office. And if you would like to see a professional headshot of this dog, you can look on my website under the Our Team, and he's in there along with the other one who is still sleeping.
That's awesome. Very,
They
very
both have
cool.
jobs. That particular dog saved a refugee during a hearing who was incredibly anxious. And we had a break and he held the dog and he calmed down enough to be able to finish his hearing. So,
Awesome.
yeah.
So cool. Yeah. So cool. All right. Let's, okay. I think maybe we've already kind of covered this. We'll do a couple more questions and then we're kind of getting a little bit late in the evening here for Ronalee. So I know agencies can be done outside of Canada. Well, you can submit.
They have to be submitted in conjunction with another type of
application. Yeah. And so Mohammed, this is something, what are the chances to get approved? Once again, it's not something that Ronalee and I can really address. Although I'll tell you, it's not so much approved as to, even getting them to entertain the request. So,
yeah.
All right. Okay. Let's jump now to number 6 on our list, which we're going to zip through. So what are the agency factors? We've covered that. Whoops. Now, what are the essential supporting documents? We really don't have time to go through the big, long laundry list.
I've sort of been trying to get through that as we've been talking. Yeah.
We've talked about them. And one, I guess I'll add on there is if you are trying to prove the impact of something, say on family, let's say if one of the parents has to leave and the child has to stay with a family member here, or there's some other factors like that. One really, really critical component is to get an opinion from a psychologist, and and have that assessment done where they can professionally assess the the impact psychologically and otherwise that the separation, say, in a family could have. In other cases, if there are like underlying health concerns, and getting a medical practitioner to provide a letter to confirm, yes, this person needs this treatment, and they may not be able to opine on the state of the medical facilities in the country in which the person's going, but we can research and we can provide evidence to support that, or even get a medical practitioner in the home country to provide evidence. So these expert reports are really, really a critical component to these, that people, that should be included. And yes, they cost money, but they can really make or break the difference, because an officer, although they don't have to just accept everything they see, they have to give due attention and acknowledge that it's coming from a professional, and they can't just dismiss it like they know better. At least that's what the federal court cases have told us. But can you add any other additional supporting documents, Ronalee? Anything else?
Again, anything that you can think of, absolutely. And both individual documents, case law, and country condition documents. Like, for example, if I've had the case where a grandparent is going to have to leave Canada, I will provide articles that talk about the positive impact that grandparents have in children's lives. Right. I've got a bank of them now because I've represented more than one grandparent. This is the one time that you get to sort of reuse some things like this, but I'll always check to see if there's new articles that have come out. But that's, again, it's, researchers, academic researchers, psychologists have written articles about these sorts of things. So those are the kinds of things that can go in for the officer to consider. This is how we end up with hundreds and hundreds of pages in these applications.
All right. I'm just going to, I think it's this one. I've got so many buttons here. Let's pull this. A kind response. I love these responses. So writer K says, such comprehensive discussion of H&C, very informative. Thank you so much, Mark, for inviting Ronalee, and you're a very tech savvy, Mark. I appreciate it. Hey, you should have seen me scrambling before so you can see I'm still trying to figure out which button do I push here. I've got everything all kind of sorted out, but yeah, you're very, very welcome. Anything else before we wrap up with kind of what to expect after you submit the application? Is there any other?
Yeah. Was that our last bullet point? I thought we had one more.
One more. We've got one more, which is the steps. So we'll hit that one right at the very end. Mm-hmm.
Yeah. Okay. So steps. So H&C applications, there's two steps. In the first step, the officer will examine whether or not they feel that there are sufficient humanitarian and compassionate factors to allow the application to be approved in principle. So as long as you make it through step 2, your application will be approved and you will become a permanent resident. And a very important part is you have to wait until you get that preliminary approval to be allowed to apply for a work permit. And I know this is something, Mark, you really wanted to highlight. Yeah. So you don't, remember I said I have 2 clients who are at like the 19-month mark and they still don't even have that approval in principle letter yet. So they've had to be without work this whole time. Unless you're going to be working without authorization, you can't get a work permit until you get to that first stage of processing. So that's really important. So not only is these applications really expensive and you might need expert reports and you might need like a psychological report, you might be without work for a really long time as well, unless you're willing to work, take that risk of having unauthorized work and really getting in trouble and even being able to find somebody who'd be willing to employ you. So that, of course, is why we don't recommend it. And then you have to wait until your work permit is processed. And what's the current processing time for in Canada work?
Yeah, probably 100 days or something like that. I can't remember. Yeah.
So the second stage of processing, they look at whether or not you're inadmissible to Canada. So they do you have to do a medical examination and find out whether or not you're medically inadmissible to Canada. They will complete your criminal and security checks. And you also have to show that you're not financially inadmissible, so that you're not going to require public funds to sustain yourself. But you can get a waiver of that. So if you're not able to be financially independent, like if you're an elderly person and you're going to be living with your children and your children have said you're going to live with them, they can still waive that requirement. But, if you haven't already provided evidence of how you're supporting yourself, you got to get a job, and you've got to show that you can support yourself financially, or in other ways so that you can support yourself financially once you're allowed to work. So that's the second part. And they'll also want updated application forms if it's been more than 2 years since you initially submitted your application. And now I have a couple of clients who are coming up on 2 years, so I may have to redo their forms, which means I probably need to charge them some more money. But
Yeah.
anyway, so that's what happens in the second part. And then
And
after that, it's just standard processing. You submit your application to confirm your permanent residence through the portal. You put your photo, the same as all the other permanent resident applications who are within Canada. So
one thing I'll point out, and on this whole world of unauthorized work. So, give you another example of an agency we filed in our firm. It was for a father, and unfortunately, his wife kind of fell off the rails. She was the Canadian, he was a foreign national, and they had 3 children, Canadian children, and they just weren't able to get the spousal sponsorship done. And dad stayed on visitor status and extended to the point where it got rejected. Then he came to see me. But mom, unfortunately, struggled with addiction and things like that, and was just not able to care for the children. And the relationship fell apart, and she basically was out kind of living on the street, and it was not a good scene. And, divorce was the path that they were going down. Well, these 3 Canadian children, they're not going to be able to, take care of themselves. And dad had to work, to be able to provide for the family. And so in that situation, if the circumstances justify it, given the length of an H&C processing, a TRP and a work permit together sometimes can help to bridge that gap. But the processing
yes,
time for the TRP and the work permit, are often a year at a
yes,
minimum in the best
yeah,
of circumstances. But if
yeah,
you're looking at over 2 years to process an H&C, it may be worth it at the same time that you file an H&C, or even before you get it submitted, to prepare and submit a TRP and an open work permit application if the circumstances justify it.
yeah,
And I've done that a couple times, probably 3 times, and Ronalee's the same as I am. If an individual we feel doesn't have a really good shot at an H&C, we're not going to submit an application that we feel is frivolous.
yeah,
And when we do take on clients, we honestly feel, based on our experience, and we've been at this for 20 years or however long it is, that there is a chance and it's worth submitting the application. And
yeah.
so, so generally there's usually a decent shot at it. And so if you can get the open work permit and the TRP, then in some cases, the applicant may be able to start working even before they reach that first stage of approval
Yeah.
with the regular H&C processing.
Yeah. I used to not bother with TRPs because the approval in principle would come in about the same time as the TRP might be submitted or might be approved. And the timing for applying for a work permit wasn't as long. So it just didn't seem to there was no really point. Like I thought, you're going to get a work permit after you get approval in principle in just as much time as it's going to take for a TRP. But
Yeah.
now I would be changing my mind about that. I would now be telling people, yes, pay me a few more $1,000s to do a TRP as well. But if you have a case where the person's not going to be working anyway, like lately, I seem to be doing a lot for elderly people who are not
Mhm.
working age anyway. So in that case, it's irrelevant. But yes, I agree. When the circumstances are valid, and you can always have, you can request urgent processing with evidence. You can see if a member of parliament would be willing to poke IRCC, hey, this is a really worthy case. Are you willing to process this a little bit more quickly? Maybe you'll get lucky. And there are also special provisions for temporary resident permits and work permits for individuals who are in situations of family violence, and they
Yes.
do get processed much more quickly.
Yeah. And it also makes sense to also talk about the vulnerable worker open work permits that are
Yes,
also available
yeah,
in events, circumstances where there's an abusive situation in your employment relationship. So those are also a possibility, and those do get looked at pretty quick. Now,
yeah,
you have to have your evidence. It's not a slam dunk just by making the request. And we had tried to make that request for an applicant in what I thought was pretty justifiable circumstances, but the individual had not taken certain steps to, report the violations to employment standards and other things to really document the abuse. They just left employment, and in the end, that application was rejected, and they had to go home. But there are other avenues, and guess how you can figure out what those avenues are? You
By having an individual consultation.
right with Ronalee and and myself to reach out to us, and in the description of the video where you're watching this, you can find links to both Ronalee and our office. All right, let's wrap up with just a couple last questions, and then we're gonna say sayonara. So Yima says, I'm in my post-grad work permit right now with spouse and 6-year-old. Our permit is valid until March 28th, 2026. When are we supposed to start submitting H&C application? Thanks.
Not.
Exactly. Exactly.
Supposed
This
to
is
submit an
not
H&C
something.
application because the situation for international students who have post-graduation work permit, these factors do not apply. And one thing that we didn't list is that you really have no other option.
Yep.
Right.
Yes.
So
Yes.
post-graduation work permit holders are supposed to be getting skilled work experience and then applying through express entry. So you have another option. H&C is an application of last resort.
Yes.
It's supposed to be when you have no other options, or at least those other options are not viable.
Yes. When everything else fails, or they're not
Right.
viable. That's really the foundation of this, for sure.
So if that person came to me, frankly, I probably wouldn't even entertain a consultation, but my answer would be no, you can't. Not that you can't, you can, but it is highly unlikely that it would be accepted unless there are significant extenuating circumstances.
You bet. And just to help Ronalee as well, I'm almost positive Ronalee would accept the consult, but what she would do is explain all of the other viable options that are actually available and better than wasting any effort on an H&C. And both Ronalee and I love to talk with people whose work permits are expiring March 28th, 2026, instead of March 28th, 2024, right? Like in 5 days, which is usually when you guys book the consults. So we love to talk to people and help strategize years in advance instead of when all else fails, then you come to us. So
I tell people it's like you've gone to the doctor when you already have 4-stage cancer and you expect me to be a miracle worker. I am.
That is absolutely correct. Okay. Let's see here. Yima, just to qualify this, she says, I'm in the CEC pool, but has low score and has a PNP profile as well. Can I apply for agency? Thank you. Yima, book a consult. Just there's the links in the description.
Can you? Probably yes. Should you?
No.
Maybe not.
Nope. Absolutely. And then we'll wrap up with a comment here from Margin Tech. Immigration should make available work permits for all, even conditional approval, but having people not authorized to work does not make sense at all, just common sense. So I get what you're saying. If you're wink, wink, nudging that, well, you're not going to take enforcement action against someone. Enforcement action against someone. I get it. It'd be helpful if they just authorized it, like, they did say for a refugee application, even though that's different, and, issued an open work permit. But the problem is they're trying to make sure they're not incentivizing people to file these applications when they really don't have a foundation, like Ronalee has so adequately described here. These factors don't apply. So that's really the balance.
And if people can't be removed, they are entitled to apply for work permit. So, if you're from a country where there is a moratorium of removals to that country, but you don't have status in Canada, you can apply for a work permit. It's the people who can leave that can't get work permit and that choose to remain in Canada and work unauthorized. That's a lot different.
That is exactly the case. All right. I think I'm hearing something. I think I am. Yes. Yeah, there it is. All right. This is our sayonara. So Ronalee, thank you so very, very much for joining me, and all of you. Thanks. And hopefully this was helpful. Hopefully it gives you at least a better understanding when someone's trying to convince you to do an H&C when you have other options. All right, everyone. Take care. Have a great evening, Ronalee. And sayonara.
Thanks for having me. Okay. Bye now.